Okay, so transfer of home to the community spouse. It's an exempt transfer, and this is one type of transfer that we ask courts to approve. You have a home that's owned by husband and wife. The wife or the husband does, the spouse, the healthy spouse, the community spouse doesn't have a power of attorney. We want to transfer the house to the community spouse to avoid the Medicaid lien. The transfer is exempt. It's not going to have any impact on the ill spouse. So, that's typically a count. One of the counts. First count is usually a request for guardianship. This could be one of the subsequent counts asking for permission to transfer the house to the community spouse. It's going to benefit the loved ones, and it's no negative impact at all on the communities, on the institutionalized spouse, since it's an exempt transfer. This is another transfer that typically occurs, and we ask for permission of the court to do this. Transfer the home to a caregiver child. Again, the transfer is exempt as long as the child who's living with the parents meets the caregiver child definition, which is care that exceeded normal support. Child is there, um, administers medications, takes the ill parent to the doctors, and was there living in the house providing this higher level of care for at least 2 years. Uh, Seems like the individual meets the caregiver child exception, and typically judges will permit these transfers to be made. Again, a transfer of a home to a disabled adult child is an exempt transfer. No negative impact. It avoids a Medicaid lien. So if the child is a minor, blind, or disabled, if you have an award letter from Social Security or SSI, that is that's the qualifying document. There's no issue about proving whether the child is disabled or not, and the court will typically allow this type of a transfer. Transfer the home for the fair market value. It's really like a sale of the ward's home. You typically have to meet the requirements for a sale of a home. That is, some counties require you to have a contract of sale. Many don't, but some do, and you need at least 2 appraisals proving that the house is going to be sold for fair market value. And then transfer of liquid assets. If you're going to do a plan where you're going to transfer assets and then pay for during the 60-month look-back period, you want to show that, hey, this is what we're planning on doing, Judge. Transferring this amount of money out. The incapacitated is in the facility. He's using or she's using this much per month plus all of their income. It's enough to cover all of the costs that are going to be incurred in 60 months. No negative impact, and we're going to transfer it to the loved ones. The loved ones that are mentioned in the will are going to receive the assets. And often the courts will approve. It's not saying Medicaid is not bound by what the court does. The Medicaid could decide against it, and that's just the risk that you take. But as long as you meet the requirements of the Henry Carey case and the Trott factors, you'll be permitted to make these transfers. Okay, so I told you about the retaining sufficient assets, and then once the penalty expires, the person's eligible for Medicaid. And that's the presentation. Thank you.
Thank you, Don. So I have a question for you. Just a quick question. You talked about a couple situations where you've actually done these carry applications before, caregiver child and things like that. Have you ever done them for more sort of borderline planning, like annuity planning or 5-year gift planning, which we're going to talk about later, by the way?
I have. I've done them for both actually, and gotten approval from the court. The court is not, the court is not saying, hey, I'm guaranteeing you're going to be eligible for Medicaid. Definitely not. And since you're giving notice to Medicaid, if you're making these applications, Medicaid sends in a letter and says, hey, we're not appearing and we're not bound by what the court said. And that's true. They're not bound by it. But, if you're showing, hey, there's $1.5 million, they need $500,000 to get through the next 5 years, and we can transfer a million, there's no impact, why not allow it? Courts will typically allow you to do that. Or same thing with annuity planning. I mean, there's sufficient cases out there, Mark, now that, as you know, that have approved annuity planning. So you have cases to point the court to say, hey, this is a valid way to go in order to preserve assets for loved ones.
That's great. I've had mixed results with that. Sometimes the court's willing to approve an annuity plan, for example. Sometimes they're not. Depends on the specific case, those factors that Don outlined, the 5-part test. But the bottom line is that, this type of in-rate carry guardianship Medicaid planning, it's an important and valuable tool, and we're really grateful to Don for explaining it to us. We got the guy who did the case explaining the case to us. So thank you very much, Don.